Good evening, Dean, classmates. For the first case, Triple V versus Filipino Merchants, GR number 160544, February 21, 2005. The topic of this case is about deposit and the obligation of a depositary. For the facts, on March 2, 1997, at around 2:15 o'clock in the afternoon, dined at the petitioner's Kamayan restaurant in 15 West Avenue, Quezon City. The Asis was using her Mitsubishi Galant Super Salon Model 1995 with plate number UBU 955 assigned to her by her employer Crispa Textile Inc. On the said date, the Asis availed the valet parking and entrusted her car key to the petitioner's valet counter. A corresponding parking ticket was issued as receipt for the car. The car was then parked by a petitioner's valet attendant, a certain Madridando, at the designated parking area. Few minutes later, Madridando noticed that the car was not in its parking slot and its key no longer in the box, where the valet attendants usually keep the keys of the cars entrusted to them. The car is whether the petitioner is liable for the loss of the subject vehicle. The ruling. The SC ruled in the affirmative. In a contract of deposit, a person receives an object belonging to another, with the obligation of safely keeping it and returning the same. A deposit may be constituted even without any consideration. It is not necessary that the depositary receives a fee before it becomes obligated to keep the item entrusted for safekeeping and to return it later. To the depositor, petitioner cannot evade liability by arguing that neither a contract of deposit nor that of insurance guarantee or surety for the loss of the car was constituted when the Asis availed of its free valet parking service. Furthermore, the parking claims tab, embodying the terms and conditions of the parking, including that of relieving the petitioner from any loss or damage to the car, is essentially a contract of adhesion, drafted and prepared as it is by the petitioner alone, with no participation whatsoever on the part of the customers, like the Asis, who merely adheres to the printed stipulations therein appearing. While contracts of adhesions are not void in themselves, yet this court will not hesitate to rule out blind adherence thereto, if they prove to be one-sided under the attendant facts and circumstances.